Case by case. I personally believe that less is more. I'm all about the story of the case. You want to change somebody's mind or you want to convince somebody, it's about the story. So you need to know what your story is and you need to fill in the blanks of what the breadcrumbs are to get you to the end zone with that story. So you'll see lawyers that show up to trials with 47 banker boxes of garbage. I'm not that lawyer. I think that is really suggestive that the lawyer who's got the 47 boxes is shitting in his or her pants and don't know what they really need, so they need to bring everything, or they're trying to intimidate their opponent that look at how much paper I got. It's not about throwing paper at the judge. It's about telling that story in a way that's going to appeal to the judge, bait the hook for the fish, not the fisherman. Who's your judge? What do they like? What is their temperament like? Know what that is and indulge that fish and use that knowledge to help tell your story. So typically, what evidence would we typically use? Okay, well, in a financial case, obviously we want to have information regarding somebody's income. We want to have information regarding assets. And when I talk to people about what do we do with property in a divorce case, property issues, we basically have to deal with your equitable distribution, right?
Yes.
Yeah, so we need to identify the property. Hopefully by trial, we already know what's there. We need to classify the property. If there's a classification issue, marital, non-marital, hybrids, whatever the case may be, our evidence needs to focus on that. We need to value the property. So if we don't have a stipulation of value, we need to either have an expert testify, or if our client can be qualified. In Illinois, at least, a property owner can testify to their opinion of value of property. So I could have my client say, my house is worth X. How do you know? You do need to lay a foundation. Well, how do you know that your house is worth X? Well, 14 houses in the subdivision that are like mine sold within this range. So they need some foundation for that. And so they need to come up with a value. And then at least by the time of your closing argument, you need to have some proposed distribution for the court as part of your proposed judgment. So that's the evidence that would follow the property. If it is there may be issues with dissipation or marital waste, and you would need evidence with regard to that. So it's all kind of driven by the issues in the case. And that exercise that I gave you before about visualization, that's kind of a great way of figuring out what evidence you think you're going to need. Now, I have a friend, I think Miles knows of, Kerry Mogerman, he's currently the president of the AAML. And I did a Zoom interview of him a couple of years ago during the pandemic when we were all bored. And I said, how do you get ready for trial? And he said, well, I sit down with my team. We sit down at a conference table like your conference table, and we just start shooting the shit about what are our points in controversy? Where do we have an issue? Because from the issues, your evidence and your proofs for your case will derive. So the starting point is, what are my issues? Do I have an issue of what is Mr. Self-employed guy's income? How do I prove up his income? What evidence do I need to prove up his income? I have his testimony. Maybe I have his CFO testifying to his distributions. We've got the tax returns. We've got the K-1s. We've got maybe an expert who is coming in. But say I'm on the other side, I'm defending that. And I think his representations of his income are malarkey. Well, how do I prove that he is making more than he says he's making? Oh, well, I have the bank record showing that he deposited 30% more into the family account over the last 4 years. than what he has represented his income as being over the last 4 years. Does that make sense? I mean, it's all driven by the issues and what side of the issues that you're on. The hardest part of our job as lawyers is thinking. It's just thinking and taking that quiet time just to noodle over an issue. And it helps to talk to your coworkers about it and to brainstorm with it, or your mentors or people, just to kind of work through it. There's another thing that I've done over the years when I'm trying to think through my case. It's called a mind map. You guys ever hear of mind mapping?
Yes.
Yeah, mind mapping is something that from time to time on certain cases, I will use that. I don't use the app. I'll actually do it with magic markers and paper or on a whiteboard. Kind of helps me think through things. When I do use that more than any other time when I would do it is at the end of the case, I will brainstorm with whoever I tried the case with talking points for my closing argument. And so we use a mind map to kind of do that exercise. Frankly, what most custody battles consist of are beauty contests and character assassination. And the issues are driven by your statute, by the various factors that the court is to look at. That's your starting point. And that will pretty well guide what evidence you need to get from this witness. Has there been domestic violence? That's a factor our statute looks at. You need to probe your client in terms of talking about the history. One of the things that's really helpful, I think, when you have a custody case, more so than a financial case, although in that instance as well, is doing a social history with a client. And that is you're sitting down with them, block out 2 hours, maybe 3 hours. I like to have a paralegal there to take notes and just talk about the history of the marriage. Listen to their language that they talk about. There may be common words that they come back to that you might be able to weave into your opening statement or your closing argument or your theme of your case or your client's testimony, et cetera. And that exercise I find very helpful to do that. That helps you gather the evidence of what you're going to need to show good mom. And your focus, at least for me, my focus is always on my client's strengths more than focusing on the other guy's weaknesses. I believe positive evidence is more persuasive than tearing down evidence. Political consultants would disagree with me, but positive evidence, when I'm organizing the structure of my direct examination, I will start with my client's strengths. I will then move into my client's weaknesses. Okay, because I want to get my clients' weaknesses out there where I can spin them before the other guy gets to them. And then I've got to kind of do cleanup messes on a rebuttal examination. So I'll bring those out. Notice I don't bring them out in the beginning and I don't bring them out in the end. I bring them out in the middle. The most memorable part of your examination is the beginning and the end. Primacy and recency. And that comes from Aristotle, okay? He wrote a book called Rhetoric thousands of years ago. And a lot of the principles that great orators and great communicators use derive from that. And so one of the things that derive from him is this notion of primacy and recency. So get the good stuff out first and get the good stuff out last, all right? So first, your client's strengths. Next, your client's weaknesses, maybe, or maybe next you want to go into possibly towards the beginning, the other guy's weaknesses at that point, okay? And then you want to finish up strong with more of your client's strengths at the end of the case, all right? One of the other things that Aristotle said is, all good rhetoric, all good advocacy would include the following: ethos, logos, and pathos. Okay, those are Greek words. Ethos is the credibility of the arguer and the argument and the client. Okay, ethos, the word ethics derives from the word ethos. Okay, and that's why I say to all my associates, you never, ever, ever fudge the truth with the tribunal, because once you have that tattooed, the judge isn't going to believe you, and you can make great arguments. And if your ethos has been diluted, you won't be as effective in the courtroom. Same with your client. Don't let them make stupid arguments in a pretrial motion. Control your clients. Don't let them, a lot of lawyers that I know, it's too much work to fight with the client to tell them they're being self-destructive. So, fuck it, let them do whatever they want. I'm going to get paid. No, that's not good lawyering. That's not good lawyering. Your ethos gets screwed up when you do that. Okay, so you need ethos. You need logos, which is the logic of the argument. Does it make sense? Is what I'm asking for, is what I'm maintaining through my examination sensible, reasonable, operable? Pathos is the emotional pull of the argument. Now, a lot of lawyers that are all pathos. This poor woman, it's just, they're just emotionally vomiting on the courthouse floor all day long. That's not what necessarily sells to a court. What sells to a court is that combination. There's got to be logic and structure. There does need to be emotion, and there needs to be credibility of the arguer. Again, if it is testimony, we lay the foundation if we need to lay the foundation. A witness can testify to what they remember, what their sensory observation was. I saw the car going down the street, their sensory observation. They can testify to a conversation. Now, if they testify to a conversation, they need to lay that foundation for that conversation. It's a little bit of a silly rule. It's a bit of an anachronism, I think, but when did you have that conversation? Who was present when you had that conversation? What was the subject matter of the conversation? Was anybody else in the room when you had that conversation? That's a typical foundational dance for that. And then you go into the testimony and deal with any objections after that somebody might have to hearsay or something like that. If it's an exhibit, you would basically have the witness identify the exhibit. Mrs. Jones, I'm going to show you now what's been marked as Petitioner's Exhibit 1 for identification. What is this document? This is an email that my husband sent to me. When did your husband send that email to you? He sent that email to me on March 11th, 2021. Is this email in the same condition as when he sent it to you? Yes. How do you know this is the same email? Well, when I got it, I printed it off that day. I also recognize his email address as in the sender portion of the email. It also involves a disagreement we were having on March 11th of that day. Then at that point, I think you've authenticated enough. Then you would say, Your Honor, I'm moving for the admission of Petitioner's Exhibit 1 for identification as Petitioner's Exhibit 1. Okay. And then you would, depending upon what your local custom and practice is, I would give the judge that original exhibit. In some courts, you give it to the clerk. If the judge already has it because you have a bench book and you've already stipulated in your exhibits, Judge, I'd move for the admission of Petitioner's 1, which is in your bench book. And the judge would say, any objection? The other side doesn't object. Then the judge would have the clerk reflect in the clerk log that it was admitted. That's how you would do that, okay? And then, of course, there could be objections, and you just have to be prepared for those.